Are we live? Are we live? We're live. I see it now. We're streaming live on Facebook. Fantastic. All right, a couple of things. Hello and good morning, Signature Real Estate Group. Thanks so much for joining us this morning. We have a very, very awesome topic today because I will tell you, we get 100 questions about it, probably a month. And so we thought it was really important that we brought somebody on to talk to you guys about probate and what happens if somebody passes away before you sell the house, during the time that you're listing the house, you know, all of those things. So we're going to have a discussion with Miss Amanda Wedl about that. But before I get there, I thought it was really important that we announce our Spirit of Signature Award. So last month, I'm going to blame Chris because he's not here. But we had in the month of May, our Spirit of Signature Award recipient is none other than Mrs. Erin Patrick. So just a few things about Erin. I thought this was probably one of the sweetest messages that we received when somebody got a nomination. It was in fact from her husband, but I will tell you there were 4 or 5 other nominations for Erin throughout the month for things that she's been doing. I've been watching even on Facebook for some of the stuff that she's been doing for our community and just going above and beyond. But I did want to read this one because I thought it was really cute and amazing, by the way. I would like to nominate Erin Patrick for the Spirit of Signature Award. Erin goes above and beyond when it comes to helping other signature agents. From teaching intense boot camps, ninja selling, and now starting spin classes during quarantine to make sure people are staying active. She's always thinking of others and how they can be successful in this industry. What most people don't see is Erin takes many late night and early morning phone calls with signature agents to assist with their business. Erin spends her free time reaching out to elderly members of our community who may need assistance in any way possible. She even delivered flowers to a woman in Summerlin who had expressed to me that it was the anniversary of her husband's death. As a husband, I am very proud of her, but as a company member, I couldn't think of anyone more deserving of this award. So that's from your hubby, but very, very well deserved, Erin. I know that you have been doing a ton of stuff within the community, so thank you for doing that. Thank you for going above and beyond, and congratulations. All right. So with that, I am actually going to hand it off to Mrs. Shelley Panzarella for our mortgage moment.
Yay. Hi, everyone. Congratulations, Erin. Well deserved. So happy for you. And what great words that your hubby got to say about you. Love that. So I just wanted to jump online. We too have had a lot of questions around down payment assistance programs. If you haven't already checked out our mortgage moment on Monday, please do. There's 5 topics or 5 differences between the home is last and the home is possible. But I wanted to also let everyone know, not only are those 2 programs, down payment assistance programs, available, culinary through Nevada Partners is back open, and so they are starting to get everything started again because the hotels are back are reopened again. And so if you've had borrowers who were originally green light approved and kind of on hold are back to work, we can go through that process to get them back into that green light approval for our culinary employees. And then we've had a lot of requests for a first responder down payment assistance program. And I want to share with you, this is the first time that we're letting everybody know that we do have a program available. We've gone through some of the training for it. We're getting through the rates and all that good stuff, but it is going to be for our first responders. So your EMTs, your firefighters, your police officers, your nurses, actually even your civil services, and even if they're volunteering for that, so they're not necessarily employed 100% as a firefighter, but they're volunteering, they too can be eligible for a 2% or 3.5% grant. So if you have any questions, not just about this new down payment assistance program, but any of the topics on down payment assistance between home at last, home is possible, culinary, or this new down payment assistance advantage, please make sure to reach out to one of our Prosperity Lending loan officers and know that we're always here to help you. That's all I got.
Thanks, Shelley. Thanks for the mortgage moment. So what you're saying is there's free money?
Free money. Yes, we can show you the money.
For buyers. That's kind of what you do real well. Thank you.
Thank you.
All right. I appreciate that. Now, a couple of things, couple of ground rules before we get into this, before I introduce Amanda. Shelly is monitoring our Facebook page. Brandon is actually in Utah at their office, so he's not going to be monitoring. If you have questions, you can put them in the Facebook thread if you'd like, or you can put them in the chat or the Q&A here on this page. Either way, I will be monitoring the Q&A in the chat, and Shelly will be monitoring our Facebook page. If you have any questions, please don't hesitate to put them in there. So without further ado, I'm going to share my screen, and we're going to get started with Mrs. Amanda Wedl. Amanda actually did my my trust, my will. I will tell you that, I didn't mean to do that, but it just happened. I will tell you that it was probably one of the easiest experiences I've had. Although you are having discussions about, okay, so what happens when you die? And then you have a discussion about what happens when the person that you left in charge dies, and then what happens when they die. It is probably, and I don't understand how she's always like very encouraging. It was a very, it was a good meeting in the sense where I really understood what it meant to have a trust, why I needed one, what the will was for. And so I encourage you to talk to her in regards to your own trust and will. Just remember, it'll probably be depressing in the beginning. But that's not what we're here for. We're here to talk about probate in Nevada and actually special concerns that are involving real property. And so what you can expect during our discussion here is an understanding of what probate is here in Nevada, assets that are subject to probate, selling real property in probate, and how a trust avoids probate. Just a little bit about Amanda. She's actually an attorney here, certified financial planner in Las Vegas. She has a boutique estate planning firm that specializes in estate planning, asset protection, probate, trust administration, estate tax planning, and gift tax planning. So as you can see, she pretty much knows a lot about a lot when it comes to this stuff. So I am going to really quickly just hand it off to you, Amanda. I know we've done some of the introductions. I'm in charge of the slides, so if I screw that up ahead of time, I apologize. Just let me know if I'm ready for next and I haven't gone there yet. But let's talk about probate in Nevada. What is the big deal? Differentiating between probate assets and those assets not subject to probate. And if you want to introduce yourself before that, please go ahead.
Okay, well, thank you. Yes, I'm Amanda. And as Vandana said, feel free to call me or email me with any questions. I like to be available to any partners in the community. A lot of questions that you have are very important questions, but a lot of them are easy to answer. So the best way is to send me an email, and I'd be happy to help you redirect you in any way I can. First of all, to understand probate, one misconception is if I have a will, there is no probate. That is wrong. The only thing that says if probate is needed is how the assets are titled. So when you're thinking about your client and selling their home and wondering if it's subject to probate or not, the only thing you're looking for is how the title of that asset is held. Is the title in a decedent's name, a deceased person's name? That is the biggest question. A will is simply the client's or the deceased person's instructions. The will is simply instructions that can guide the probate process. So for example, if somebody has a will and they pass away, the will says who's in charge, who's the personal representative. The will would say how they want those assets distributed upon their death. But if an asset is in a decedent's name, that asset is subject to probate, and the will helps guide that process. If somebody passed away without a will, without any planning, the Nevada legislature has created a will for these people. It's called intestacy, and laws will govern that part of the probate process. So if you want to go to the next slide, I think we'll discuss what assets are actually subject to probate.
So I'm gonna, if you wouldn't mind, I'd like to actually talk through possibly, I called you about 2 weeks ago, right?
Mhm.
I have a client who purchased a home about 3 months ago, and she fell down in the house, went to therapy to start walking again. And while she was in the rehab center, she actually got COVID and then passed away about a week ago. And so her family called me and said, hey, what do we do about the house? Now, this was pre her passing away. She was actually in the hospital. They just found out that she was COVID positive and that she probably wasn't going to make it. So I called Amanda, and I think this might be a good example on how, like, we proceed maybe with the discussion, because it happens more often that way than it does people planning for it, right? Not a lot of people plan to die, or they think that they're going to live forever, and so they don't plan for what happens thereafter. And that was similar with her. So I called and I said, hey, she's got nothing. She's got her house, right, obviously, that she had bought. She's got probably a couple $100,000 in the bank, and she's got 2 daughters, a grandkid, and then great grandkids. So now what? And so maybe that could be how we sort of start the discussion on that, if you don't mind, because that happens a lot, right? We'll see that. And also, I don't want to take away from your slides or your presentation either, but I want you to cover that segment if you wouldn't mind.
Right. So I think, Vandana's story is your worst case scenario, is that, something hit the fan and no planning was in place. It's almost too late, or becoming too late to do any planning, which highlights the importance of you do planning before you need planning. But in this case, what I did was I checked. The first thing I always do is I check how the real property is owned. So you look at the assessor's office, you can look it up. I'm sure you guys as realtors do this all the time. You can look it up by street address, the name, the APN number, whatever you have, and pull the most current deed and how is the title to that house listed. In this case, it was in her own individual name, which tells me that it's going to be a problem if she passes away. Once you have the APN number, you can then go to the recorder's office and search by the APN number to make sure that a beneficiary deed wasn't also recorded. You can't find a beneficiary deed on the assessor's website. You have to go to the recorder's website. But a beneficiary deed is a deed that says, if I die, I want my house to go to this particular beneficiary. A beneficiary deed is helpful because that is a form of planning that does avoid probate, because by operation of law, you are saying, if I die, this one asset, this one real estate goes to this person. So that is a probate avoidance planning tool. And in this case, Vandana's client did not have a beneficiary deed either. So then we go to what kind of planning can she do? And in this case, we were not able to access her. She was in a facility where we couldn't visit. We couldn't do, she couldn't sign. We couldn't get things notarized. For deeds, they have to be signed. They have to be notarized before they can be recorded. So that left almost all of our planning moot, because to do a beneficiary deed, which is one document, still need to be signed and notarized before it could be recorded. If she were to create, or I were to create a trust for her, she would have had to sign the trust, and then she would have had to sign the deed transferring her real estate from her name into the trust name to avoid probate. So those planning tools were taken off the table because we couldn't access this lady to sign these documents and have a notary come visit her, even electronic notary services. It was too difficult to plan with the care facility. And she ended up passing away very soon after that anyway. So in her case, because she died with an asset in her own name, with no beneficiary designation, her family will need to go through probate, asking the court's permission to act on this deceased person's behalf to then transfer the legal title. So if I were to give you just a very honest way of how I explain probate to my clients is, if Amanda Wedl has title to a bank account, let's say Vandana's case, a lady had a bank account of $100,000, $200,000 and a home, let's say worth $300,000. Amanda Wedl had that bank account and that home in Amanda Wedl's name, and then Amanda Wedl died. Now a dead person owns legal title to those assets. And that's what probate is for, is a court supervising the transfer of title from a dead person's name to the new beneficiary. So simply put, in the end of probate, it's simply asking a court order to show the title company, to show the bank that here's a court order authorizing you to transfer title from dead Amanda Wedl's name to the beneficiary, whoever that might be. So what assets avoid probate? Those are assets that are not in the decedent's name. Maybe they're in a trust name. They're not in the decedent's individual name. Another asset that avoids probate is property that has a beneficiary designation. So I talked about a beneficiary deed that can be recorded. That avoids probate. If you have retirement accounts that have a beneficiary designation, those avoid probate by operation of law. If you have a bank account with a payable on death or a transfer on death, that avoids probate. Another common that avoids probate is joint tenancy. I'm sure you guys as realtors, you have a lot of property held as joint tenants. Maybe husband and wife as joint tenants. Maybe husband and wife community property with right of survivorship. If one person passes away, that property automatically becomes the property of the surviving joint tenant owner. Assets subject to probate that can be confusing is tenancy in common. So any property with two people's name on it, like in real estate, that is not joint tenancy or community property, that is what tenants in common. So the deceased portion share, maybe it's 50% or whatever fractional interest that decedent owned, that part now is subject to probate.
So really quickly, so I just want to point out to all the agents there, it's so important that the client, whoever is taking title, right, into the property at closing, that they understand what these are, and you're not the person to explain it to them. It needs to be explained to them through an attorney. Title usually sits down and explains the difference between them, but you do not choose how they take title. And this is primarily one of the reasons. It is a legal thing, right? So you would be acting outside of the scope of your license, and you shouldn't be doing that. It is a decision that they need to make.
And that's a great point, Vandana, and just to piggyback on that, it is, and title companies, I don't think necessarily can give that legal answer either. There's a difference, for example, for a husband and wife as joint tenants compared to husband and wife as community property with rights of survivorship. Probate purposes, they kind of act the same, but for income tax purposes, for creditor purposes, for all these other legal purposes, there is a huge, huge difference. This isn't the seminar to describe those differences, but that's something that if you ever have questions about, you can ask me, or have your clients reach out to an attorney. It's very important.
So the other thing is I think it's important to understand the timeline. So for instance, this client of mine who passed away, she didn't have a trust. She didn't have a will. Now her property is going to be sitting in probate. Her children have figured out the bank account stuff, and that's great. But her property is going to be sitting in probate. How long is that timeline?
Yeah, so let's move on to now we're in probate. So somebody died with an asset in their own name. Now it's subject to probate.
Is that the next slide?
I think so.
Sorry, go ahead.
Yeah. What is probate anyway? Okay, we kind of talked about this. It's the court supervised process of, in the end, asking for a decedent's property to be transferred to the beneficiary. But along that line of probate, there's all of these kind of landmarks that have to be hit, all of these timelines, all of these duties, which lengthens the probate process. So what seems so easy, hey, Amanda Wedl died, she has a husband, give her the court order to have the real estate be transferred to her husband, Brian. How hard is that? Well, it can take 9 months to a year. That's how hard it is because of these hurdles that you have to go through. So in the beginning, I would say the longest part of probate process is the beginning, because you have to wait until you have a death certificate. And death certificates in Clark County can take, 2 to 4 weeks after somebody passes away before somebody is even in possession of a death certificate. You cannot file anything into probate without having a death certificate, because the attorney has to prove that this person is deceased. The other problem is, once that probate petition can be filed, there's always these timelines called a notice period. And the notice periods is usually about 2 weeks. And the purpose of a notice period is to give anybody that's interested in that specific probate, meaning a beneficiary, a creditor, a family member, give that person time to object, time to question. So you have this notice period of 2 weeks. So when you file the petition, you have to wait at least 2 weeks before the court will even hear the case. But that's not all anymore, because probate in Nevada is so backed up. Our Clark County the commissioner, the probate commissioner, is about 2 to 3 weeks behind. So when I'm an attorney and I ask for the earliest possible hearing date I can, I am usually trumped by the clerk of courts and given a hearing date 2 to 3 weeks later. So it's likely, and what I've seen this whole past year, meaning that 12 to 15 months, is from when a person passes away to when you have letters of administration, meaning proof that probate is open. It can take 8 to 9 weeks, easy, before somebody can even start administering on an estate. So it's a very long, that beginning part is a pain. So depending on the size of the estate, administration just gets longer and longer and longer. So for all of you realtors, you're probably always going to be in a summary administration or a general administration, simply for the fact that real estate in Clark County is pretty healthy. Most houses are over $100,000 in equity. So that puts you in what's called summary administration. Summary administration is when the value of the decedent's assets are between $100,000 to $300,000. General administration is for any estate over $300,000. So you see that it doesn't take a big estate to get into general administration, which is the largest probate process in Nevada. And I would say summary and general administrations can take anywhere between 8 months to a little over a year.
So really quickly, just listening to you and the timelines and how it could take 6, maybe 9 months, right? What worries me, and I think that what agents need to understand is that somebody who has purchased a home that is in that 100,000 or 300 or even above $300,000 range, right? It could take up almost a year to really figure out what's happening with that asset, and to leave your clients unprotected like that is probably not the best way for them to move about in life, right? Unfortunately, we've had, like, with COVID coming about, I think it's brought a little bit more light into, holy crap, we could actually die tomorrow, right? And so because of that, and so one of the things that I always do is when we close, I've always talked to my clients about the homestead, right? Because they're going to file the homestead declaration. And I've also mentioned to them, like, hey, if you've got, you may want to consider putting the home into a trust. I recommend that you speak to Amanda. Here's her contact information. And I've never, beyond that, I've never really pushed it, right? But this is probably a good opportunity for you to add that as your after closing 30 days later of, okay, you're settled in, you've moved into the property. Here's a couple of things that I recommend you do. Talk to an attorney who can help you put your home in a trust so it's protected. Then get the homestead. Here's the discussion about the homestead. Here's what it is. And Amanda can actually, so when you did my trust, Amanda, you filed the homestead for me as well. There was a question that came about is how quickly can you do a beneficiary deed after the original deed of trust? And would it be a good idea to do that right after closing? And then is it the same regular recording costs?
Yeah, great question. So as soon as the home has been recorded with the county recorder, you can do a beneficiary deed. The beneficiary deeds are recorded like a normal deed. Is subject to the same recording costs. So $42 in Clark County is the recording for a beneficiary deed. And you'd be recording a declaration of value with it as well. There is an exemption. So when you file a beneficiary deed, there's not a transfer tax associated with it because there's a transfer tax exemption. I want to caution you and say, do not use a beneficiary deed as your method of planning. It is not as efficient as a trust for two huge reasons. One, trust also deals with incapacity planning. So like Vandana said, Amanda's killing off everybody. What she forgot was we incapacitate people first before we kill them.
That's true. That's true.
So there is a risk that you can become, or your clients can become incapacitated. And maybe that's—
Which was what happened with my client, right?
Right.
She was incapacitated, and had she planned for that, her
Right.
daughter or granddaughter could have taken over her estates.
Right. So a trust would have prevented all incapacity and death planning. A beneficiary deed is only death planning. The other bad thing about a beneficiary deed is that it does not transfer clear title, because there's a statute that says if the deceased person owed money to creditors at the time of death, a creditor can take that property back and use it as a method to satisfy a creditor claim. And the creditor period, I believe it's like 9 months, the creditors have to take that real estate back from the beneficiary. For that reason, a title company will not issue clear title to the beneficiary until that statutory timetable has run. If property instead was transferred to a revocable trust, clear title is available right away when somebody passes away, and it's the most efficient thing. So I don't want to give the impression that a beneficiary deed is the best form of planning, because it's not. It's only reserved for certain types of clients. I would say I do one beneficiary deed a year.
So that's part of their consultation when they sit down with you is,
absolutely.
here's what we think here's what I think you should do. And if you don't do anything, this might be an option for you, right?
Right.
That way they're not completely unprotected if they pass or whatnot. Okay.
Absolutely. Right.
Cool. Next slide.
So probate players, so simply an executor and an administrator are the same people. It's usually the decedent's family or loved one who's in charge of the probate process. An executor is if the decedent had a will, a last will and testament. An administrator is a person that is appointed when the decedent died without a will. Heir at law is if somebody did not have a will. Nevada says who that decedent's heirs are. Simply put, it's the decedent's closest relatives or married. So if I died without a will, my husband is my heir at law. If I did not have a husband at my death, my kids would be next in line. Kind of follows what most people want anyway. Beneficiaries are the people under the will of who receives a gift from the estate. Attorneys obviously are needed to help guide the executors or the administrators through the probate process. And then, of course, the District Court of Clark County, Commissioner Yamashita is the one who is providing the orders. It is his orders that are needed before things can be done in probate, before property can be passed to the beneficiaries. So I really want to spend more time here as real estate agents, realtors. You probably have had a case where you had a probate sale, or you have maybe you had a client that died and now the estate has to take over. If I die and my estate is in probate and I own a house, and let's say my loved ones want to sell the house in the probate process because no beneficiary wants the house, or nobody can afford the mortgage on the house anymore. There's some reason where it makes more sense for the estate to sell the real estate instead of holding it for a beneficiary. For example, I have a case right now. My client, her mom did die of COVID. The mother had a home. The children cannot make the mortgage payments. They have their own homes, and one of the sons wouldn't be able to take over a mortgage of that size anyway. And for that reason, they're choosing just to sell the house and take they'll receive the equity as the beneficiaries, but the house will be sold. When you sell real estate through probate, there's more duties that you have to show the court. For example, the first thing that has to be done is the attorney has to file what's called a notice of sale, that, hey, there's this estate, the estate of Wedl. The estate of Wedl owns a house on Esk Drive. The estate is thinking about selling the real estate. And this is actually published in a local newspaper. So potential buyers have the ability to bid on this property of the estate that might be sold. When you think, let's say you're representing an estate that's going to sell the real estate, you have to put in the agreement, the purchase agreement, that the sale is subject to the probate court approval. That is a requirement for our court to confirm the sale. If that language is not in the agreement, a court will not provide an order to sell that real estate.
So if I represent a seller who is the beneficiary in a property, right, through the trust or whatever, I have to make sure that whether it's in a counteroffer or an addendum, that there is some language that says subject to probate court approval.
Right.
Cool.
Right. So if for probate sales, you as a realtor, your client would be the executor or the administrator of the estate. Not necessarily the beneficiary. It will be the person in charge of the estate. So your client would be the executor or the administrator of the estate. And any buyer, when they see that contract, the buyer has to be aware that the sale is subject to probate court approval.
I'm going to back up. Sorry,
Yep.
I'm going to back up for 1 second too, because I think there's a lot of confusion from agents on how we actually have that client sign off on the document. Because if it is in a trust, right, let's say there's a trust that owns the property and they're selling it, we usually have whoever is the trustee sign off, comma, trustee, and that's how they sign their documents. Now, if it's an administrator or an executor, would it be, for instance, let's say I'm the executor, it would be Vandana Bhalla, comma, executor of, and then the name of the trust. And that's how I would sign off, correct?
The name of the estate, yes.
Or the estate, sorry, yeah.
Yep. So like Amanda Wedl, comma, executor for the estate of, whatever. That's exactly right. So all of your paperwork would show the estate name as the seller, and when you sign, it would be the executor or the administrator on behalf of that estate name. And then the buyer would need to see in the contract or in the offer that the sale is subject to probate court approval. So let's say now you are representing an estate. The estate is going to sell its real estate, its home, let's say. You are representing the estate. You've listed the property, and now you have a buyer, and the buyer knows it's subject to probate court approval, and you have a signed contract. It's been negotiated, there's counteroffers, whatever, but it's a signed and agreed upon contract. Once you have that contract, now we have to do what's called a confirmation of sale or a return of sale. That's where we're reporting to the court that this property is going to be sold. It's for fair market value. It's in the best interest of the estate, and you're asking the court to confirm the sale, really to bless the transaction. So you have to do this extra petition to show the court that all of these things were fairly conducted, that you're talking about that the sales price is comparable to the appraised fair market value, and if not, you're explaining why. You're disclosing the realtor the fees given to the realtors and showing why that is beneficial to the estate and that the fees aren't too high. The listing agreement fees are normal. You're proving to the court that the sale is necessary for the estate administration. So that's a petition that also has a hearing attached to it. So
you keep saying you are going to be doing this. Who's you? Is that you like Amanda Wedl, or the attorney, or is it me? And how closely are you involved in this process, and how closely are we working together?
Okay.
Sorry.
So, I don't mean that's a great
throw
question.
You off track, but I want to make sure that we have a good understanding of that.
Yep. So when I say you, so it is the attorney filing all the paperwork. So let's say it's Vandana is the real estate agent. I'm the attorney. And let's say Shelly is the executor for the estate. She's a family member for the estate. So Shelly would be my client, and she wants to sell the real estate. I would be filing the petition for confirmation of sale on Shelly's behalf. And I would be working with Vandana as well. I would be asking her for the signed contract, because that's attached to the petition to prove to the court that that there is actually a valid contract. I would also be asking Vandana for like kind of the Alta settlement statement, so we can tell the court the expected costs and the fees associated with the sale, because we need to report what the estate will probably net to the beneficiaries. So I would be in contact with Vandana for some paperwork that I might need, but I would be, as the attorney, I would be filing all of this information on behalf of my client, Shelley. This would go to a hearing. So again, I would ask for a 2-week notice. So the hearing and 2 weeks after I filed the petition. But like I said, the hearings always get delayed an extra 2 to 3 weeks because of the backlog. So from the time that you have the signed contract to the time where you might be able to get the court order confirming the sale, it could be 4 to 5 weeks, 4 to 6 weeks. So this is a very important area that you're very communicative to the buyer and the sellers, so they understand that there is a couple extra week timeline than a normal sale. The sales go off well. There shouldn't be a fear that somebody is buying property from an estate. There's no real risk to it. It's just extra time. It's just going to add an extra 4 to 5 weeks to your normal process. So,
sorry, quick question. One of the things that happens or that people are afraid of is that if they don't show up as a purchaser to the court hearing, that somebody else could come in and outbid them and the judge would accept them. So do you mind if we talk a little bit about that? And
yeah, I think that's on the next slide, I think. The next slide or the slide after that. Yeah, so you're right. So once it goes to hearing and the court says, okay, I'm going to hear this case, this estate, Shelley, as the executor, wants to sell the real estate. It does go through a bidding process. Again, the court wants to make sure that if it blesses any sale, that sales price is the absolute best sales price it could get. So it wants to make sure that there's no other willing buyers out there that are willing to give the estate even more money than the original contract. So what happens is that you'll go and you, meaning the attorney, has to be there. And I always recommend that both the seller and the buyer's agent be there. The client, Shelley, or the actual buyer of the property doesn't necessarily have to be there, but the agent should be there with clear instructions from their client of what happens if there is an overbid. Do you want to bid additional, or do you want out and you're not willing to go any higher? So when we're at court, I'm with a seller agent, the buyer's agent, Commissioner Yamashita will call our case, say this is a confirmation of sale. We're selling real property on Alta Drive. This is the APN number. The sales price was $250,000. Do I have any overbidders? And Commissioner Yamashita will wait to see if there's anybody that's going to come forward to bid on that property. And Yamashita is usually taking bids in about $5,000 increments.
It's not $100 more.
Right. So what I've seen is that a property has to be, when I see overbidding, it's usually for properties that are very low in fair market value. So the 100,000s, maybe low 200,000s, where more real estate investors are, that's where I see more overbidding. I don't see overbids in your normal, like, you know, Summerlin home, let's say, or your normal neighborhood home. I don't see a lot of overbidding there. For very high-end property, you don't see overbids usually unless there's something very unique about that property.
A lot of land.
Maybe, yes, a lot of land. That's where you see, again, more interest.
Where do these people find out that they can actually go to court to overbid anyway?
Right. So if you remember, I said that there is, you have to file a notice of sale before you even are able to sell the property. You have to show to the court that you gave the general public notice that you intend, that you as the estate were going to intend to sell the real estate. And that's published in local newspapers. I publish mine in a local newspaper called Nevada Legal News. There's another paper, I can't remember what it's called, that some attorneys publish there. But that's one way that real estate investors will look for these notices. I think there's some other companies that follow the probate filings, and if they see that real estate is a part of the probate process, they'll reach out to the executor or the attorney because they're trying to buy things up.
Got it.
I've sold quite a few through confirmation of sale, and I've never had somebody overbidding.
Awesome.
So you hear about it, but it is a little bit more rare.
So as a licensee, I'm just trying to, and hi Brandon, I know you're back, so please jump in as the broker here. But one of the things that I think is important to understand is that once you've actually gotten a court approval, right, then there's a timeline for the court will say, yes, we approve this purchase agreement for this amount, and then you have to close by this date, right? And usually, and is that correct, Amanda?
Usually it just, once the court approves the sale, then it goes like a normal sale. It's whatever the contract said was the closing requirements. And at that point, to be honest, the attorney's out. The attorney's like, okay, here's your order, you can sell it.
I'm all done, right?
I'm done, yeah. Like you do your work. But it goes like a normal sale.
So generally, once it's approved, it could be 4 to 6 weeks. One of the things I think that we should probably remember is that if you are participating as an agent on, as the buyer or even the seller, you should understand that all of the contingency timelines, due diligence, appraisal, all of those. Now, if you don't indicate in the contract that they're supposed to be handled after court approval, you must do them already. And if your client's already done those and they get to court and they get outbid, they've lost all that money that they've spent on inspections and whatnot. So if you are on the buy side of a transaction, and I'm just speaking to the agents in our company, you may want to consider putting in a timeline that suggests that all contingency timelines start 1 day after probate court approval. And that gives you that so that your buyer doesn't have to spend the money on actually getting all of the inspections done. Now, I know on the sell side, though, if you're representing the seller or the executor or whatnot, that could cause a predicament, because once the sale's been approved in court, and let's say you do the inspections after that court approval and something falls apart, the appraisal doesn't come in, and then the deal falls apart, now you have to go back to court as an attorney. So there is, I guess, so what would be your suggestion on that? And Brandon, jump in if you want, in regards to like what you advise on that too, because I always find that to be the hardest part of this whole scenario, right? Is that I understand that the seller needs to sell it, and that if you don't, and once you get to court, then the whole process starts over. So there's no benefit to the seller to have that timeline start after the court approval.
That's right. Yeah, you're absolutely right. You want to make sure you have that contract, that due diligence is done, that you're ready to go, that as soon as you have that court order gets filed that same day, and now title has marching orders to close the deal. I mean, that's how far you are down
in the transaction.
Right. Yeah, because exactly, if you ask for court approval before you were done with the due diligence process and the buyer had a legitimate out, you have to start that whole process over. You have to find a new buyer. You have to file a new petition for confirmation of sale with a new buyer fax. And you have to wait for that hearing date. And if the appraisal went stale, you'll have to get a new appraisal. You know, you want this so far down the line that the only thing left is the exchange of keys and money after that court order is given. So again, due diligence is done, you know it's going to be a go. That's when the petition for confirmation of sale is final or filed by the attorney. It's going to take about 5 to 6 weeks to get a hearing date with the court. That's the kind of that waiting time where we're all just kind of waiting around, twiddling our thumbs. But after that hearing, once we get that court order that same day, that order is filed, and then you're good to go. Then it just goes like a normal close. And just for everybody who's not aware, probate court only hears every Friday. So this is not a court that you can go any old day and have all of these days available to be heard. Probate court only hears every Friday. That's it.
So when you say, just to clarify, when you say you want that process as far down the line as possible, you, the attorney, you, the seller, the executor, so, right?
Yep. I'm talking about, I'm depending on the real estate agents that this is a valid contract, due diligence is over, the inspections have been completed, and you know, this is a very willing buyer, and the buyer is not going to back out of it, because once you have the court order, the buyer has to buy the property.
Yeah. Okay. I know you've gone through quite a bit of this stuff already,
yes.
Right? We've talked about this.
Right.
We only have a few minutes, so I do want to, it's already 10:23. We've got about five minutes or so. If I encourage the agents that are listening, if you have any questions, go ahead and put it in the chat or the Q&A, or even in the Facebook thread. That way you can, we can have Amanda ask them. Obviously, you'll be available to talk to them even afterwards if they have any questions in regards to any of this stuff. So is there something that you wanted to really run through? Because we've only really got like 5 minutes. So is there something that you want to really get to?
I don't think so. I think just, again, the key of probate, it all comes down to legal title. That's the only thing you really care about, is how was legal title held when the decedent died. And if the decedent had property in his or her own name, you're going to go through probate if it did not have a beneficiary designation. A way to avoid probate is to have a good trust in place, a revocable trust, a family trust. They all mean the same thing, a living trust. It's just a very simple way to efficiently plan, where the legal title is owned by the trust itself, not the person. So Amanda Wedl had a home, but Amanda Wedl now has a trust. Now the home is owned, the title is owned as the Wedl family trust. So the easiest way I can describe it is your trust is like a suitcase. You leave my office, I give you a trust, and it's like a suitcase. Everybody needs a suitcase. We've all used a suitcase before, but we would never take an empty suitcase on vacation with us. That is stupid. We would always pack our suitcase. That's the whole purpose of a suitcase. Same like a trust. You have a trust, it's great. You bought a trust, but your client has to pack the suitcase, or what's called fund the trust, transferring the legal title of that real estate into the name of the trust, transferring those savings accounts, the checking accounts, investment accounts into the name of the trust. Legal title is everything. So the trust has to own the title to these assets in order to avoid probate. And like I said, also provide incapacity planning. So a beneficiary deed is only a death type planning. It's not an incapacity planning. So really the trust is the only slam dunk way that we make sure our clients are protected both in incapacity and upon death, and that we are providing our clients' loved ones the most efficient way to transfer assets without the need for court.
And with a trust, I think it's important to remember too, that there's no court supervision. It's in
Right.
this slide right here, is that you as a beneficiary and you as the person who's been assigned to take and handle that trust are the one in charge, right?
Right. There's no approval. So if you're the trustee of a trust, let's say your mom passed away and you were named as a trustee of her trust and you wanted to sell your mom's real estate. Now you're just hiring your own realtor. You're selling it as a trustee of the trust. The title company is transferring title from the trust to the new buyer. There's no need to do a confirmation of sale. There's no need to get a court approval. It's just you as the authorized legal representative of the trust selling that property.
Awesome. So I'm slowly going through these slides. We've covered quite a bit of this anyway. So I know that we're sort of getting ready for wrap up and Q&A. And one of the questions that but my understanding is a lot of people have is how to get a hold of you. Did I do that correctly? That's all your right information, right?
Yes, that's right.
Okay.
And if you guys email me, of course, is the easiest way. Just remember the 2 L's, one for Wedl, one for law. Some people forget that second L. So just remember that there. Yep.
Okay. So Amanda.Wedl at Wedl. You say Wedl, I say Wedl, but you also say my name correctly, so I'm going to learn yours.
Okay.
Amanda.Wedl at wedllawfirm.com is the best way to get in touch with you. Obviously, you're here in Tivoli.
I'm in Tivoli Village. Yep.
Yep. So you're not far from our Summerlin office, which is great. Shelley, were there any burning questions that anybody had that we should probably address?
No, just on Facebook, it was just her contact information.
Voila, we've answered that question too. All right, you guys. And with that, thanks again, Amanda. Thanks, Shelley, for monitoring. Thanks, Brandon, for being in 2 places at one time. And thanks to me for moderating. I will see you guys all next week. Happy Tuesday and go sell some shit.
All right. Bye.
Bye.